Hello blog readers. I'm here today with esteemed class action litigator, partner Jerry Maatman from Seyfarth Shaw. On Monday, March 26th, the Supreme Court acted on two important cases, both of which had the potential to significantly influence class action litigation. Today, Jerry is here to explain the importance of both cases to employers and litigators. Jerry, can you first tell us about the China Agritech v. Rush case?
This case was argued on March 26th, and it has everything to do with the ability of federal courts to open their doors to class action litigants in successive, or what are known as tag-along class actions. It's actually a securities fraud case. It emanates from the Ninth Circuit, and it's examining the continuing vitality and extension of an earlier decision by the U.S. Supreme Court in 1974 called American Pipe. Since that time, courts have applied what's known as American pipe tolling as a way in which to control successive or tag-along class actions after a decision on a motion for class certification. The China Agritech case will determine the extent to which American pipe can be used to shut off and end once and for all the attempts of successive class actions to be filed over the same, in essence, cause of action.
Thanks. Next, can you touch on the debate over Cypre?
Well, just this past week, the Supreme Court also turned down certiorari in a challenge to what's known as a Cypre distribution in a class action. It's a French term for what to do with the corpus of a settlement fund that can't be distributed because class members cannot be found. And typically, class action litigators will designate a charity or a third-party organization that will receive the residual of a common fund that cannot be distributed. And there are debates on both sides of the V as to the propriety of such. The Supreme Court turned down a request to review a Cypre distribution in the famous Keepseagle case involving a $380 million settlement involving Native Americans. It's interesting insofar as Jeff Sessions, when he became U.S. Attorney General, issued enforcement memoranda to U.S. attorneys on the civil side indicating that they should not be negotiating Cypre paragraphs in terms of civil enforcement actions, and that's contrasted with a typical negotiating strategy of the EEOC, for example, with employers to provide designation of third-party organizations for distribution of Cypre funds. So the jury, so to speak, is still out, and it seems as if there'll be a continuing debate, especially at the government enforcement level, as to the propriety of Cypre distributions.
Great. And what significance did these debates have in respect to employers?
Well, with respect to China Agritech, even though it's a securities fraud case, I believe that it will impact on workplace class action litigation, and one could view it as either a door opener or a door closer of a future ruling in terms of the ease or inability of plaintiffs to access a second or a third or fourth bite at the apple in these sorts of cases. Commentators who were present at the oral argument thought that the defense got the better part of the argument. So I would look for a fractured decision, but a defense victory coming down sometime between now and June. With respect to Cypre, I don't see that going away anytime soon. The issue is, will large Cypre distributions draw objections and therefore tie up employers trying to close their files and bring certainty to the conclusion of a class action? So I think that the issue to be debated there will have to be decided sometime in the future.
Thanks for the overview, Jerry, and thank you for our readers for tuning in. As you know, we will continue to monitor the latest class action and employment law trends. Remember to stay tuned to the blog and follow us on Twitter.